Welcome back. And so, as we said earlier, national security is high on our agenda this morning, and we're going to be reviewing some of the resolutions from the debate, both on the floor of the House of Representatives and the Senate yesterday. And joining us this morning is legal practitioner Barrister Ekemini Udim, who joins us virtually this morning. Barrister Udim, it's good to have you again on the morning brief. You may need to unmute so that we can hear you. Can you hear me now? Good morning, Mr. Udim.
Yes. Good morning.
Yes, indeed. So let's begin with the proposition to designate bandits as terrorists. What are the implications of this, or is this, too late in the day, having seen the damage that bandits have wreaked on many communities, not just in Nigeria's north now, but as we see it to begin to move a bit further down the north central and even into the southern parts of the country?
Well, it's the proper thing to do. As a matter of fact, there is nothing known as banditry under the Nigerian legal system, the Nigerian criminal legal system. So all through my years in the university, we never had anything like that in criminal law. I mean, even in practice, I'm a lawyer in practice. I've never had anything like that in criminal law where someone is charged to the courts for banditry in the federal high court or in the state high court. So it is unknown to the Nigerian criminal justice system, the word banditry. The law does not know anyone with the description bandits. It's either you're a criminal or you're not. It's nothing like, I think it was in the last administration that someone just found something convenient to begin describing them as bandits, that they are not terrorists, they're just bandits and all that. The kind of description that Senator Shehu Sani once gave, where he talked about deodorization. So somebody just chose to use deodorants in the description of persons with these criminal tendencies. And I am saying that the time has come for Nigeria to call these persons with the name they deserve, with the name known to the Nigerian criminal justice system. It's either you're a terrorist or you're another thing under criminal law, but not banditry, not bandits. Bandit is totally unknown to the justice system of this country. And therefore, if the Senate is taking steps to ensure that those that, do the actions that we have been seeing, we've been watching everywhere, Nigeria is being encircled, people using AK-47 to destroy communities, people using all manner of things to decimate the Nigerian society, then they should rightly be described in accordance with the law. And this act is act of terrorism and not banditry. So if the National Assembly now considers it necessary to ensure that they are described the proper way, I think that is very good for Nigeria. It will end the cycle of confusion because, like I said, nobody has been charged to court for banditry. There's no provision of our criminal law, that provides for banditry. So that means that if we continue to describe these persons as bandits, it means that forever they will never be taken to court to stand trial because there is no law for them to be charged with. No law on banditry. So the National Assembly must come clean and ensure that those that do this kind of, heinous crimes in society are properly described. So I am totally in support of that. I have heard some persons in the National Assembly saying, no, it's not supposed to be so. And so please, for God's sake, there is no need for us to sit on the fence anymore as a country. The country is encircled as we speak. There is no 2 days that pass without us hearing stories of people being murdered here, communities being sacked and all of that. So there is no need for political correctness anymore. And why do you even want to be politically correct on issues like this? So let them be properly described to save this country so that once people go wrong, there will be a law to charge them to court with.
My worry most of the time is I'm a student of history as well, and I try to understand where Nigeria is coming from and where we may be headed to. it's very sad that what we call, you could call them the custodians of our democracy. We are custodians of the democracy. What I mean by that is that they are the ones that are elected, they become president, governors, and all of these elective officials, I mean the politicians. They are also responsible for the failure of democracy. I think the only place we can excuse them is in 1993. Every other time democracy has failed, Nigerian politicians have been at the forefront, either with corruption or petty issues of not being able to agree, from Akintola to Awolowo to what happened in the Second Republic. We can go on. And all the signs of what played out that led us into that chaos is right here. And I'm saying this to say that, remember, when Goodluck Jonathan, former president, was president and Boko Haram ensued, it took a lot to designate them as Boko Haram. Perhaps he was busy thinking of second term. He doesn't want to offend the North. And now we're back in that space again. I don't know why it is hard to designate bandits as terrorists. So where I'm going to my question, we had Sheikh Gumi the other day, and it seems to me what he is trying to put forward is to the fact that they are excusable. More like, I don't want to use the word, maybe they have a cause. They have grievances that the state should resolve with them. So when you hear those kind of things as a lawyer, what impression comes to your mind as far as our management of our legal system is concerned in addressing security issues?
You see, in reality, there is no section of Nigeria that does not have one form of grievance or the other. Marginalization, our persons have never been in government at the federal level before. We have the resources and yet we are not allowed to benefit from it and all of that. And it is expected. Nigeria has not less than 250 ethnic groups. Before Lord Lugard merged these together in 1914, these were independent nations. The Oyo Empire, the Kanum-Boni Empire, these were countries. They were properly governed. They had their presidents, they had their prime ministers. They had everything working and functioning optimally. You know, they had diplomats, ambassadors that Nigeria has refused to have. Those ancient kingdoms, they had diplomats, you know. So now, all of a sudden, they were merged together. And so it is expected that there will be grievances here and there and all that. So if everyone was to step out there and start desecrating human lives because of the grievances, it therefore means that Nigeria will be in flames. Nobody will be left to live in the country. So what am I saying? It is wrong. And it is against the Nigerian state for anybody to say, oh, these actions are justified as a result of the grievances that these people have. It is against the Nigerian state for anyone to say that. And this narrative has continued. You know, the Sheikh keeps saying this. I have watched him, you know, recently on your channel and all that. You know, so he keeps talking about the grievances. Beautiful. Nigeria should address the grievances, not only to the persons in the north, but to every other person in Nigeria. But it doesn't call for the taking up of arms and then destroying societies, killing people, you know, sacking communities, going in, burning Christian churches, or even burning any other place of worship. So the fact that we have grievances in the country, it's not justification in law. If we have to take it back to the law, it is not justification in law. If somebody is charged to court now and is asked why he is sacking a community, you know, throwing bombs, bullets and all that, using machete, and then he comes up with the excuse that, oh, my community has been marginalized and that's why I'm doing that. That's not an excuse in law. You go to jail if that is the only excuse you have. So Nigeria must come clean as a country. No country jokes with those that are disturbing the peace of society. No country in the world. So we must be determined as a nation, the presidency, the National Assembly, and even the judiciary. You know, everybody must work to keep this country safe. Because what's going on, we are being encircled. Every day, you're hearing stories, you're hearing burning of churches, burning of other places of worship, killing, mass burials, and all of that. We cannot allow that to continue because of grievances, you know, in the country. The grievances will continue. All we need to do is to solve them one by one, but not to resort to criminality.
Well, I wonder if, grievances stand in the face of death, destruction, tragedy, and, perpetual damage in homes. I wonder if the argument stands. But let's look at some of the things that we may not be paying as much attention to as we ought to. On the floor of the Senate yesterday, the senator from Edo North, I believe, Senator Adams Oshiomhole, expressed outrage at certain conflicting court judgments awarding lesser, judgments, or if you like, sentencing to terrorists as against what the law actually prescribes, which would be the death penalty. Tie that to 2023, when Governor Diko Rada of Katsina State gave a warning to lawyers, the MBA directly, to stop helping bandits get off the justice system through bail. My question from these similar events is there something that we know that is ongoing beyond what we see that needs to be addressed, particularly with the justice system and with accusations against government officials about complicity in the security concern of Nigeria?
Well, this was observed by a senator, a sitting senator, and my suggestion to him would be amend the laws where you have life imprisonment for some acts of terrorism. You can upgrade it to capital sentence, right? The Nigerian law allows that. So they in the National Assembly cannot be sounding helpless when they have the power under the law to amend and then give stiffer punishments. Stiffer punishments becomes necessary when society is going through a whole lot as a result of the activities of certain persons in society. The law then gets amended so that we can have stiffer punishments. And that is in line with the positivist school of jurisprudence, which says that law is nothing except it is backed up with sanction, appropriate sanction in this case. Right. So Adams Oshiomhole with his colleagues at the National Assembly shouldn't sound helpless, but they should rather get to work and see how they can amend the laws to have stiffer punishments. Now, having said that, as it is today, judges only sentence based on what the law says they should. As a matter of fact, if the penalty is death sentence, no judge has the right to reduce it to life imprisonment or a number of years imprisonment. No judge has the right. If you see any judge do that, well, maybe the judge understands that the matter will go on appeal and the Court of Appeal will set it right. So it is what the law presents to the judge that the judge works with. Now, I personally have a problem with the justice system of Nigeria. And the biggest problem I have is the pace, the slow pace at which cases are being heard in this country. Look at the Nnamdi Kanu trial. It took Nigeria 10 years to see a verdict. Yes, I understand that in between, Nnamdi had left the country after his father's house was invaded. I understand that when he came back, he had been at the DSS for some time before the trial resumed and all of that. But when you add all of it, it's still a failure on the part of the Nigerian legal system that we had to take 10 years before we could hear a verdict in one trial. There are many of such cases. One of the reasons that we have delayed trials in this country is because of the absence of technology. Judges are still writing in longhand. How do you have speed when you're writing in longhand and you have 10, 20 cases to treat in a day? Most of our criminal cases are still tried in the traditional way. I have not seen, in recent time, I have not seen where fingerprints evidence is brought to the court to find someone guilty. So judges basically depend on what the police send out to the court, called confessional statements. Sometimes the confessional statement is forced out of the accused person. So we are not using forensics in our criminal justice system. And this has gone a long way to be delaying trials. Look at what happened in France. Former President Nicolas Sarkozy, he was convicted and he appealed against it. Yesterday I saw the verdict. How many weeks? A matter of weeks. If the former president of France will be tried in Nigeria, it will take him no less than 3 to 2 years before he can have verdict on appeal. So these are the issues with the justice system in Nigeria, which the federal government, which the state governments, and everybody, every stakeholder in the justice system, those that are funding the judiciary, needs to properly fund so that when someone is arrested for acts of terrorism and is taken to the court, we'll get to hear the verdicts in no time, when the witnesses are still alive, when the witnesses have not retired from service. When a man retires from service, maybe his children take him abroad. How do you bring him back to testify against a terrorist? So we need to have a system where trials are done expeditiously, when the evidence is still fresh, and someone knows his fate in 3 months or at most 6 months.
All right.
Anything outside that will continue to run in this circle. We run in circles, and Nigeria is not the beneficiary of it. Nigeria is rather losing as a result of cases going to court for too long and so on. Sometimes the person runs away. Sometimes the witnesses are no more there, so the judge charges them, and they get back to the society.
All right.
And continue to pose a problem for
Mr. Kemini, just before we let you go, one question. And recently we had a judgment, a conviction, and a sentencing of a leader of ISWAP. For somebody to be at the leadership of ISWAP, I see that person as an ideological terrorist. And the state should be clear on what to do with such individuals. But to our greatest shock and surprise, I do not have privy to the CTC, so I don't want to be quoted. But what we saw in the news is that this terrorist, this leader of ISWAP, was sentenced to 20 years imprisonment. I don't know what charges were brought against them. The reason I'm saying this is that there seems to be, I don't know whether it's a game, I don't know what is going on. Remember the Deborah issue in Sokoto? Why was there outrage? They say she committed blasphemy and all of that. When the people that committed that atrocity of murdering her, whatever guys, were taken to court, one of the things that outraged the NBA was the charges that was brought against them. It wasn't strong enough. And then to worsen the matter, due to lack of diligent prosecution, the case was thrown out because the police didn't follow through, and that lady just died like that. So when you hear that an ideological, I'm using those words very carefully, ideological terrorist who has attained the leadership of ISWAP is sentenced to 20 years imprisonment, what do you make of that kind of law?
Now, it goes back to the prosecution, because the judge decides based on what is presented to the court. It goes back to the prosecution. Perhaps the charge that was prepared by the prosecution in the Ministry of Justice was a kind of charge that is obviously compromised. So there is need for supervision. There is need. Let the Attorney General of every state of the Federation and of the Federation of Nigeria, let the Attorney General insist that before any charge against a terrorist, an alleged terrorist is filed in court, let it be brought to his attention. Let him be the one to sign. So that you don't have a compromised state council somewhere, just filing any kind of charge, knowing very well that even if this person is found guilty, his term of imprisonment is very short and the person is going to go home. That is not happening in Nigeria. So we expect that the Attorney General should be the supervisor of every criminal charge that is to be taken to the court on charges of terrorism. Because this has become a crime against humanity. If you look at crimes against humanity under the United Nations definition of crimes against humanity, terrorism is part of it. Extinction of a community is part of it. When maybe female members of society, a particular society, are exterminated, and so in that case, there will be no reproduction for a number of years, that there is a deliberate attempt to exterminate a particular ethnic group or a particular ethnic group. That itself is a crime against humanity. It can qualify for terrorism, So it is a very serious matter locally and internationally, and there is need for the Attorney General of every state of the Federation to ensure that this comes to his table so that you'll be sure that the proper charge is preferred. Because for as long as the weaker charges are preferred against anyone, that is what the judge is going to decide on, because the judge cannot, even if the judge is dissatisfied with the charge, There is nothing he can do, else he will be said to have entered into the arena of conflict and be biased. So he's supposed to sit like an umpire. And so the charges proffered must be potent charges that can bring the needed effects in favor of society, and not compromised charges where maybe a state council is given money to just proffer any kind of charge. That is not helping society, because if society eventually gets engulfed, even the Ministry of Justice is not spared from violence. The State Council is not spared from violence. And so there is need for checks and balances. There must be layers of checks and balances to ensure that proper things are done in the justice system, because what you present to the judge is what the judge is going to determine upon. So we must present what is potent and what is going to give the needed effects to secure this country. As it is right now, this country is going through so much, and we cannot continue this way into the next year. It might be too much for Nigeria to handle.
And that's why we wonder whether the lethargy in the justice system, or even the passivity that we see in the handling of cases of some as against what we see in the handling of cases of the others, is part of the complicity, that is often referred to in government's handling of issues of national security concerns. And that's why we'll continue to have this conversation as often as possible, such that we can secure some form of attention and action from those concerned. We must anchor at this point, and thank you very much, Barrister Ekemini Udim, for bringing your insight and expertise to this particular important subject matter. Barrister Ekemini Udim is a legal practitioner who has joined us on this one. Thank you for your time.
Thank you so much for having me.
We'll take a moment now, and when we return, we're not quite done with security matters yet. We'll be touching yet again on the subject matter with a point of view of exploring it from someone who is in the trenches and who may have some insight as to what's happening in the forests, where the rescuing of kidnapped victims is concerned. So stay with us for this next one. We'll be right back.